Hey, Raphael.
Hey, Dr. Paris, how are you?
I'm doing good. How are you?
I'm doing great. Uh,
Good.
we expecting Dr. Adams?
Um, I, yes, I believe so. I can send him a message. Let me check on him.
Yeah, we can wait a minute or two here.
You getting any time off for the holidays?
Not enough. Not enough.
And this is the moderator. Dr. Adams has joined us. Dr. Adams, can we please have a mic check?
Great.
Testing 1, 2, 3.
Wonderful. All right. Chair Sweet, please feel free to begin.
All right, I'll call the meeting to order. This meeting of the Board of Chiropractic Examiners Enforcement Committee is being held by teleconference in accordance with the provisions of Government Code Section 11123.5. Committee members are participating virtually today from remote locations, and board staff is present at the following primary physical meeting location: Department of Consumer Affairs, El Dorado Room, 1625 North Market Boulevard, Suite N220, Sacramento, California, 95834. The date is Thursday, December 19th, 2024, and the time is 12:31 p.m. Board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes, unless in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on the agenda of a future meeting. Please be aware that this meeting is being recorded. Please turn off or silence all cell phones. We will now take the roll call. Dr. Adams, are you able to take the roll?
I am.
Please take it away.
Uh, Chair Sweet,
I am here, present.
Lawrence Adams present. Dr. Paris,
Present.
we have a quorum.
All right, great. Moving on to agenda item 2, public comment for items not on the agenda. Members of the public may address the committee at this time. Public identifying themselves is voluntary, and their name will be recorded in the official minutes of the meeting if it is provided at the time of their comment. Will the moderator please open this agenda item for public comment?
Thank you, Mr. Chair. First, I'd like to ask, are there any requests for public comment at the physical location in Sacramento? No. Okay, and I can let you know that we don't have any members of the public attending right now. Our one attendee is from Board and Bureau Relations. So with that, I will return the floor back to you, Mr. Chair.
Okay. Suppose that means we can move on to agenda item 3, review and possible approval of December 8th, 2023 committee meeting minutes. Any questions, comments, or changes to the December 8th, 2023 meeting minutes?
I motion that we approve the minutes.
I'll second.
All right. Can the moderator open this agenda item for public comment?
Thank you, Mr. Chair. Again, we have no members of the public online, and I've just been informed we have no members of the public in the El Dorado room. So with that, I'll return the floor back to you.
All right. Dr. Adams, are you able to call the roll for this motion?
Yes. Chair Sweet,
Yes.
Dr. Lawrence Adams, yes. Dr. Paris,
Yes.
meeting minutes are approved.
Great. Suppose that moves us on to agenda item 4. Ms. Walker, are you able to provide us with an update on the board's enforcement program?
Sure, thank you. My update this afternoon on our enforcement program is going to be rather brief because not much has changed since our board meeting that we had this past October. I wanted to take a moment just to highlight the fact that we do need to identify a date in February for our next board meeting. We unfortunately don't have a quorum for January 9th, so I sent out a poll yesterday with some possible dates. As of right now, Thursday, February 13th is looking promising, so we'll follow up with a few board members and make sure, but as of right now, plan for possibly Thursday, February 13th, because we've got 3 so far and likely going to have more. Within the meeting materials, I highlighted a few key dates for 2025. Staff is currently working on obtaining the necessary approvals for the board to be able to send 2 representatives to participate in the FCLB and NBCE events that are occurring in 2025. There's the annual conference coming up this spring. We also have the FCLB regional meeting in the fall in Nebraska. And then we're also working through the approval process to get some members from the board in the NBCE test development committees. So a few things for us to do on the national stage when it comes into 2025 that we're working on. We're also gearing up for the 2025 legislative session. This year, it's both the Assembly and the Senate adopted new rules that are limiting the number of bills that each lawmaker can carry down to 35. So it remains to be seen what the impact of those changes are, but likely going to see a few less bills that we're going to have to sift through into late winter, going into spring. The key date for the committee members to be aware of as it relates to the legislative session, the first key date is February 21st. That's the last day for bills to be introduced. Right after that date is when staff is really sifting through a very high volume of bills and identifying any that could potentially affect the board or consumer affairs. And then we generally have been routing those through the Government and Public Affairs Committee to recommend board positions. Just depending on the volume and the workload across the different committees this spring, we may potentially look at a model where we route the majority of the bills through those committees. But if we have some specialized bills that relate to, say, licensing or enforcement, we may consider bringing those directly to the other advisory committees to recommend board positions. Also within the meeting materials are an update on the pending regulatory proposals. I want to highlight the concept development phase. On today's agenda, we're actually discussing basically the 3 pending proposals that are going to be affecting the unit. And then the 4th one around the petitions for reinstatement and that application process. We'll discuss it a little bit further under agenda item 7, but I am proposing that we consider consolidating those down into one proposal. So move disciplinary guidelines and that application process together. Also just want to take a brief moment to acknowledge the really hard work of our enforcement staff. They've been doing quite well. As of right now, we have 355 pending complaints, which is a reduction of about 10% from where we were at over the summer, and approximately 150 cases less than where we were at 18 months ago. So really appreciate their hard work. They've been pretty flexible with some changes to our procedures and the way we handle cases. And then we've also really expanded our special investigation unit. So we've got that staffed now with 3 full-time special investigators, and they've been doing an excellent job of receiving their complaints and really conducting very thorough and timely investigations on those. Another item that's going to be eventually impacting our enforcement program a little bit later this fiscal year is going to be the results of continuing education audits. We are beginning to ramp up the amount of audits that we're doing going into early 2025. And what those end up resulting in is then increased enforcement cases due to the board-initiated workload around failed CE audits. We've got a pretty effective path of handling those, so we don't anticipate it to be really affecting, our productivity or our throughput for the enforcement program, but it is going to show a little bit of a reflection, possibly of updated numbers as far as pending complaints that we're going to see, but probably going to see some pretty good timeframes as far as initiating and closing those cases. We've also, as of right now, have 47 pending disciplinary cases, so we're down about 15% since summer. That was to be expected as over the past 2 to 3 years, we had kind of a historically high volume of disciplinary cases, and now we're starting to reduce it down to more kind of expected level, I'd say, over the next few fiscal years. So with that really concludes the update that I had to share this afternoon. Happy to answer any questions as they relate to the enforcement program.
Thank you, Ms. Walker. Any comments, questions from the committee?
No questions. Thank you, Ms. Walker.
Walker, I had a quick question on the upcoming dates as you've laid out here. Are we, if we send representatives to the FCLB meeting in April, are they expected to be there all 5 days?
We can work with them on the travel. If there's the core days in the middle where all of the meetings are taking place, so the expectation would be that the representatives we're sending likely can attend in the middle. But then generally when we see the FCLB and NBCE events, they're pretty generous on travel days at the beginning and end of the trip. So potentially wouldn't need to be traveling on April 30th or returning on May 4th. We could probably squeeze it a little bit tighter. But those key dates in the middle, probably May 1st through 3rd, would be ideally we'd want somebody present.
Okay, and Dr. Paris, as a district chair now, you're going to be there anyway, correct?
Yeah, I wouldn't be included in the two that we're hoping to send. I would go separately under my FCLB duties as a director.
Right. Okay.
And to circle back to the question about dates, the main FCLB program would start on Thursday morning. So it would probably be like maybe get in Wednesday night, or even if you got in early enough on Thursday, you could probably, get there in time to be. Although St. Louis long travel, so probably a Wednesday night travel for any of our board members planning to attend. It's a Thursday. I think the agenda for the general meeting starts on Thursday morning.
So primarily a Thursday, Friday.
What I'll do is I'll see if I can if we can get the agenda out so everyone can take a look. Yeah, but yes, that sounds correct. I'm not positive on that, but there may be some Saturday.
Okay, thank you.
Yeah.
And I just had a quick comment or a question, I guess, on you mentioned that the enforcement, obviously we've got that staffed out a little better, and we're seeing the pending complaints go down and some of the other backlog, which I think is great. Do we see that? Do we expect that to continue going down, or is this kind of the new plateau where we see things?
I think when it comes to the number of pending complaints, we're still around 350. I think a target and a long-term goal would be to get that closer to definitely under 300, but probably closer to 250. I think there's still a little bit of work there that can be done to get that number down a little bit further, but around 250 is probably going to be that healthy, just planned workload that we're going to have for the enforcement unit. We generally tend to, as far as complaints received every fiscal year, we're generally between 500 to 700. So keeping it at about 50% of that total complaint workload as kind of an ongoing pending case number, I think is pretty reasonable.
Okay. And what's the timeline on getting those done? Are we talking about like a year or 6 months? Like how long are these complaints pending on average? Do we know?
They kind of vary. We have it's right now they're higher than we expect. We're generally pending around for about 1 year is about the average number of pending complaints, and then we've got some that exceed that, and then we've got some that get turned around quite faster. In addition to reducing the number of pending complaints, staff is also working towards achieving our targets on the investigation of the complaints. And our current target for active investigation time is 120 days. We're allocating 90 days for an investigation plus another 30 days for expert review. So we want to get to 120 on average, keeping in mind the fact that we have a pretty significant volume that that can get closed in under 30 days. And then there are some more complex investigations that will, take 6 months to a year to still complete. The other portion of that we're working on, especially as we gear up for sunset in 2026, is looking at better data around our enforcement, basically our pending complaints, because we're trying to measure our actual active investigation time versus our inactive case management type activities. Because right now, those numbers incorporate both. So when we receive like an arrest notification, and then it sometimes takes 2 to 3 years to resolve that case, it's not active investigation time. We're just tracking. There's nothing that we can do with the case until the conviction occurs. We want to be able to flesh out that data a little bit further, so that that we can show our actual active investigation timeframes, where it's within the role of either staff or an expert to be actively working on the case and then moving it to the next step. So a little bit of preview of some numbers that we want to be able to break out a little bit further going into 2025 and report during sunset.
Very good. Thank you. Any other comments, questions from the committee? I think there's nothing further. The moderator can open this up for public comment. Please.
Thank you, Mr. Chair. And first, I'd like to just check and make sure no one's joined us at the Sacramento location.
No.
Okay. Well, we do have a public attending now. So if that member of the public would like to comment on this agenda item, please either raise your hand or you can type comment in the field in the lower right-hand corner of the screen. We'll give you a moment. All right, I'm not seeing a request for comment, so Mr. Chair, I return the floor back to you.
Okay, great. I don't think we need to take any action on that. So we'll move to agenda item number 5, please. Ms. Walker, back to you to discuss agenda item 5, please.
Sure, thank you. So over approximately the past 18 months, the committee's been doing a lot of work on developing a proposal to update within our regulations, California Code of Regulations, Title 16, Section 312, as it relates to the supervision and training requirements for unlicensed individuals to assist doctors within a chiropractic practice. Over the course of several meetings, the committees discussed various aspects of the proposals, such as what those training requirements would look like, what the level of supervision for basically what indirect supervision means and what those terms are. And then at the last meeting in 2023, the committee started discussing basically the minimum eligibility requirements for somebody to serve as a chiropractic assistant. And then also the discussion was around potentially mandating basic life support certification requirements for chiropractic assistants. And then also trying to standardize the use of terms, so calling them chiropractic assistants versus unlicensed individuals. For purposes of today's discussion, within the meeting materials, we have the conceptual draft of regulatory language around this proposal. We think we're getting quite close. Keep in mind, as I walk through the text itself, there's certain areas where maybe organization or phrasing could be improved upon, and that's just solely based on, as we were developing this proposal, we were trying to make it fit within the existing regulatory language as much as possible. So we may, take it back a little bit and clean it up. But the proposal itself, we took the language that the committee last reviewed and then highlighted any of the substantial changes that were made based on the last committee discussion. I want to briefly walk the committee through that and then return it back for what could potentially be maybe our last policy discussion on this before we clean it up and bring it to the board. So I've highlighted the changes that were made there. I didn't highlight every instance where we changed it from unlicensed individual to chiropractic assistant. Like I said, from the get-go, that's just what we've incorporated here. We've taken a stab at, in subdivision A, starting to define what a chiropractic assistant means and putting the focus on, within the context of this regulation, the chiropractic assistant is somebody that's assisting the licensee in a clinical care type component. Not, the term itself is kind of, used differently in different offices, but for purposes of our regulation, chiropractic assistant means the person that's assisting the licensee with clinical care. We're not trying to unless the committee has any interest in it. We're not trying to regulate really the use of that term. So it's not going to, make it where only people with that term can use it. But within the context of our reg, we've defined what that means, and then tried to further define the requirements of the supervising licensee. So when it comes to the things that the chiropractic assistant is doing, they're subject to the supervision of the supervising licensee, and then as it gets further into the regulation, either under direct supervision or indirect supervision. But again, it's everything that they're doing really falls on that supervising licensee. We try to put some emphasis in this regulation, but then they're also covered under Section 316 Subdivision A, where they're ultimately responsible for anything that occurs under their supervision. Within Subdivision B, that's where we added, and it can be, we'll probably refine the way it's worded a little bit further, but looking at the model of what the Physical Therapy Board has when it comes to supervising physical therapy aids, they have language in there where it puts the responsibility on the licensee to really ensure that any chiropractic assistant that they're having assist them with any type of procedure has the necessary knowledge, skills, and training to safely and effectively perform that care. So making sure it's just clear that in addition to all the the training requirements, the eligibility requirements that are already spelled out in the regulation, at the end of the day, it's up to the licensee to ensure that the person is competent to perform a specific service. Even if they have, say they have the certified chiropractic assistant certification through FCLB, that doesn't mean that it negates your responsibility to also ensure that they know how to do any procedure that ends up being delegated. Within Subdivision B2 is where we put basically the minimum requirements for a chiropractic assistant who would be working under indirect supervision. So under this proposal, it's not intended to change any of the minimum requirements for any clinical assistant that's working under a licensee's direct supervision, because the licensee is there and readily available and can jump in. But the way the discussion kind of evolved around indirect supervision, the licensee isn't always going to be on the premises. Here's the minimum requirements for safety of patients that need to be established. We've tried to, based on the last discussion, put together basically 3 pathways, whether it's through examination, education, or experience. We did not include the 24 hours of continuing education as a potential minimum requirement, just due to the fact that it is so unequal to the other pathways that were being used. If somebody has the 24 hours of continuing education, they could use that pathway to then pass the FCLB chiropractic assistant certification. So they could have the 24 hours of CE plus the exam. But it was not necessary to call that out because they would have the certification program. But then we've also, as far as education level, we could entertain a little bit further of a committee discussion of what that education model could be. For purposes of the draft, we put in there that if they have education in chiropractic, physical therapy, or physical therapist assistant program as being something that would potentially work for being qualified to act in that under indirect supervision, or an experience pathway, so completed a minimum of 2,000 hours or roughly equivalent to 1 year of supervised clinical experience, whether it be as a chiropractic assistant, a medical assistant, or a physical therapy aide. And then from that section, other areas I just wanted to highlight a little bit further. So when we get into Subdivision C, I've highlighted the second sentence of Subdivision C1. The reason being, in prior text, that sentence was stricken, but kind of looking at it from the rationale behind it, I'm kind of proposing that we just potentially keep it as is, because I don't know what it's not really causing any harm to keep that sentence in there about the activity being separate from the consultation, which at all times must be conducted by the supervising licensee. So we could entertain a little bit discussion around that point, but there's some concerns that we see on the enforcement side when consultations, or it's not clear whether it's a consultation or not, but that's being performed by unlicensed staff. So we could entertain a discussion around that point. And then beyond that, as we were looking at the text, there's probably a little bit of room for a better definition of what direct supervision is. We've looked at some models from other boards, but basically just, it's more than what we've defined as indirect, we've defined quite well, but direct supervision isn't well defined in that text. So we can use some models from other boards about, basically meaning that the licensee is available and readily, present to assist immediately versus the indirect supervision model where the licensee may or may not be on the premises. And then further into the text, reflecting, so make sure I'm referencing the right section, the proposed subdivision D2 added a little bit more text there to reflect the committee's discussion about really ensuring that chiropractic assistants can't modify or deviate from the supervising licensee's treatment plan and order, but then also calling out the fact that, like, if a patient presents with some new symptom or complaint, the chiropractic assistant shall consult with the supervising licensee before providing that physiotherapy treatment that was on the original plan. Because we wanted to make sure that language wasn't saying they can't modify or deviate even if something new was to present. That's where the trigger is. They have to go back to the supervising licensee and determine how they're going to deal with that scenario. A little bit further down into regulation subdivision E, we just wanted to clarify the fact that exceeding the scope of practice, in addition to prohibiting the person from being able to apply for a chiropractic license by the board and being in violation of Section 15 of the Act, they're also subject to citation. And then we've also got in subdivision, so subdivision G is where we put all the exceptions to these rules. And that's where we've already called out licensees that are licensed by another healing arts board while acting in that capacity and scope. Chiropractic students while participating in the preceptorship program under the direct supervision of a licensee. We're going to spell out the requirements for preceptorship programs further by the licensing committee when they're updating the college regulations. So for purposes of this regulation, we just need to accept them from it. And then in subdivision G3, just clarifying the fact of, like I was talking about, when we're talking about chiropractic assistant within the context of this regulation, it means the assistant that's assisting the doctor in clinical care, physiotherapy treatment, not somebody who's solely performing like non-clinical administrative services such as scheduling, billing, general clerical duties. So as far as the pieces to the proposal, we think we might be there. We want to bring it back for what could potentially be one last committee discussion. If there's anything more that we have to add to the framework, I'd like to have that discussion today. And then the next steps would be for staff to work with legal counsel to actually finalize language that reflects the committee's proposal and potentially bring that to the board. So with that, I just want to turn it back over for a committee discussion on this proposal.
Thank you, Ms. Walker. Comments, questions from the committee?
I have just two quick things. One under 2A, the obtained a chiropractic assistant certification through the Federation of Chiropractic Licensing Boards. I'm wondering if we might want to consider to change to have some broader equivalency language for any other future, nationally recognized and approved by the board assistant certification courses.
That makes sense to me.
Kind of like we do with when we reference CCE, even though we acknowledge the major kind of player in those arenas, but we know that in the future, and to have this language have some lasting ability and not have to go back if there's another one. That would be one suggestion. And my other comment would be around the parameters of the therapy. Let me find out where I was reading that. But anyway, when we note let me think of, hold on, I'm sorry, I'm going back. Give me 1 second here. You know what, I'm gonna take that back. I was going to, just so you know where my mind was at. I was thinking that we may need to, because some of the physiotherapy, well, actually almost all of them have some very distinct parameters that drastically change how it's done with as far as intensity goes, whether it's tension on a traction table, duration of time. Ultrasound units are kind of one of the more common areas where patients sometimes can get injured with depending on the intensity of the ultrasound and how long it's used for. And I didn't know if we needed to define something so that our language speaks to the idea that there's not just, oh, ultrasound. And so it's something that kind of identifies the parameters of that particular physiotherapy plan outside of just stating, which is it? Is it E-stim? Is it ultrasound? Is it traction? But anyway, that was my thought. I'm not sure that we need that, but that was my only other thought there. So thank you.
Dr. Adams, did you have anything?
Yeah, I had a question. I'm in agreement with Dr. Paris relative to some of those parameters. I also had a question about the complete a minimum of 2,000 hours. I remember us having some discussion back a while ago about the level of that 2,000 hours. And reading the previous minutes, I think even Mr. Sweet brought up, the fact that we have 24 hours of continuing education, 2,000 hours. That just seems like a lot to put on a practice, so that they got to find somebody in that situation or train somebody to that level. And I'm wondering if we have any data on where that 2,000 hours came from.
So the 2,000 hours came from the minimum requirements that the FCLB had established for their certification program. The committee could discuss or change that requirement, but it's based on. So to clarify, just to make sure it's clear, that minimum of 2,000 hours of supervised experience is to enable somebody to be able to work under the indirect supervision. If that number, so it basically equates to 1 year of work experience. So, and it doesn't have to be within that practice. So you're basically hiring somebody or training them in-house, but once they've had 1 year of basically supervised work experience in a clinical environment, they would then be eligible for being able to work under indirect supervision. If that number is excessive, we could define different numbers, like you could do 1,000 hours or roughly the equivalent of 6 months of work experience, but it's just kind of trying to establish what that minimum qualification should be to where somebody can be entrusted to carry out those duties while potentially the licensee isn't on the premises. So that was the basis behind it. We pegged it to the FCLB requirement. We didn't put in there, we can, but just 24 hours of continuing education as a standalone just seemed very, very low as far as what somebody could potentially get to meet that requirement. So we didn't put that in the draft language. We could, it seems quite low that if you have like a high school graduate takes 24 hours of continuing education, are they qualified to work under indirect supervision? So that's where that number came from. And it's meant to be, not overly burdensome for licensees that already have their staff that have been working under the supervision for over a year. They're eligible for that indirect. So we can entertain a discussion around changing that number, but that was the rationale behind it.
I got you. That makes sense. All right. Thank you for that clarification. I have nothing else. I think the language that you've created looks pretty good.
Yeah, I just had a couple quick things. I mean, maybe I'm looking at section E here, which is on page 4 of this agenda item. Kind of maybe more of a procedural question. I see that because it says chiropractic assistance who exceed the permitted scope of the practice shall be subject to citation by the board. So are we saying this this regulation? I know that in the past, there's been some discussion of if they're not a licensee, do we have jurisdiction over them? I guess is the question. So does this give us jurisdiction to provide violations if they exceed the scope?
That's a good question. It's not gonna change our jurisdiction over unlicensed individuals. So anybody that doesn't hold a license issued by the board has limited jurisdiction over them, and the jurisdiction is to be able to issue citations for basically unlicensed practice or illegal use of the title Doctor of Chiropractic. Within our regulations, we have Section 15 of the Act that prohibits the unlicensed practice of chiropractic, and then we also have Section 310.2, which does similar. It prohibits the use of titles or practicing chiropractic without a license. The intent of that edit is just for clarity, to basically demonstrate the fact of if a chiropractic assistant steps over the line of what's in the bounds for being under somebody's supervision. Like, say you've got a scenario where the supervising licensee has written treatment orders, and then instead of following those orders, the chiropractic assistant starts deviating from a different plan and performs some other procedure. They're practicing chiropractic without a license, and they'd be subject to citation by the board for the unlicensed practice aspect. But where it differs from our licensees is that we can't go after unlicensed individuals or chiropractic assistants in this case for other types of violations, such as like incompetence or unprofessional conduct. We can only go after them for unlicensed practice, and then anything else, any of their other conduct potentially subjects the licensee to either citation or disciplinary action.
Yeah, that was going to be my next question, is whether we need to include any language saying that the licensee could also be held responsible for exceeding the scope if if we deem it, if the enforcement deems that they've been kind of instructing them to go beyond the scope of what they should be doing, or something to that effect. Does that make sense? I don't know if I explained that well.
It does. I think that might be a good addition to the language. We've got in our regulations, we have Section 316 subdivision A, which has some very, very broad language that basically holds licensees accountable for the conduct of anybody that's subject to their supervision. But it definitely wouldn't hurt to be a little bit more specific within this regulation, since we're already making the call out for what happens if you exceed the scope, probably also clarifying for licensees. So I think that would be a good addition to our language.
Okay. Yeah, maybe if it's already worded properly in that other statute, then we can mirror that language in this one, perhaps. But I'll let you guys work on that. I guess I just had a broader question, since I'm not a practitioner. And you mentioned this at the beginning of your explanation, I think. Is it confusing to use the term chiropractic assistant in this way for those that are practitioners that may have maybe a broader definition of what that means, just as in their practice generally? I guess that question's more for Dr. Paris and Dr. Adams.
Well, I mean, the term CA has been used for years, and there's been programs. Parker has had CA assistant programs. I know that the FCLB has one now. I can't remember the chiropractor's name out of Tennessee. That that's kind of his project and something that he does for FCLB. So there's multiple programs that are out there. Some management companies actually do CA programs through their management company. So that's why I think, Dr. Paris's comment about, having it broad so we're not locked into, but I think having it be accredited makes sense. Having it be accredited and, something that's a program that's been established and well known for a while makes a lot more sense than somebody just kind of popping something up. But that term CA, I've never thought of it or heard of it being. You mean like a derogatory term, or just not really capturing what we're expecting?
No, I didn't know. Not that it was derogatory in any way. I just wasn't sure if practitioners use that term more broadly than the way we're defining it here, and if that creates any confusion. It's just not a huge concern. I'm just wondering if that's an issue.
Well, I'll speak to our office. As Kristen pointed out, the only people that get a designation of chiropractic assistant in our office are those in the office that have a part to play in aspects of the care of the patient. So they might work on the front desk, but they're going to be dual trained, not only to book appointments, but they also might be asked to go do physiotherapy or assist in the examination process.
Understood.
If they're upstairs doing billing or paperwork or, things like that, they're not typically referred to as a CA.
Got it.
Although I guess technically they would be.
That's all I had. Unless Dr. Paris, did you want to add something?
No, I think that answered it well. I mean, I think it's hard when we say like certified program or accredited program, or I don't I don't really know necessarily that that's available. You know what I mean? I mean, from the broader picture, other than we take like a national organization like FCLB that's recognized generally in the profession, and have the ability to kind of review their program. And so I think when I was thinking of equivalency, that's kind of what I was thinking of, something that's coming not necessarily from not to denigrate other programs out there, but anybody can prop up a program and apply for CE and put something in front of us. But I think what would give us the assurances is something from a group that's recognized broadly in the profession, nationally, ACA, the national associations, FCLB, et cetera, and then also has the content that we approve of, we think meets our. So that was my thought. And not to pigeonhole us into, naming, I think kind of, we can name them like we do CCE, but we want some equivalency language so we can, have ability to have other programs qualified, down the road.
Ms. Walker, are we seeking a motion on this matter?
So I have one clarifying question for the committee, just kind of actually following your question. Is there a necessity for us to potentially consider, I don't want to use the term title protection, but maybe not, but if it's pretty well known and distinct that chiropractic assistants are the ones that are assisting with the clinical aspect, or at least part-time. I mean, they could be cross-trained and provide both services, but if it's pretty well known that, your billing person that's exclusively doing billing or exclusively working the front desk and has nothing to do with any other component of the office wouldn't be called a chiropractic assistant, is it necessary for us to maybe consider calling that out in the regulation, like basically prohibiting somebody from misrepresenting somebody as a chiropractic assistant, or not? Like, not to throw additional layers to it, but just the public might not be as aware as licensees. So is that necessary or not? I'm just kind of envisioning maybe an enforcement kind of matter where we get a call and it's like, well, this chiropractic assistant did something. Staff would probably be going down the path of thinking it's going to relate to these regulations, but they could be talking about somebody else. So just a thought. It could go either way. And then the other portion of it is if this bill's wholly complete, besides just cleaning up text, staff would be requesting that the committee maybe consider a motion to move this proposal forward to the board with the discussion today and final text.
So was I hearing that can we define it, like use the language, use the title, I don't even want to call it a title, use the language to find, chiropractic assistant, and then, as defined in our regulation, the duties as defined in our regulation versus having to, I'm not sure how to say that. Maybe you know, when they are performing those duties, we would consider them a chiropractic assistant because it doesn't really matter what you call them in the office, right? It's what their function is in that moment. And we have, for example, in healthcare systems, you have health techs and you know, that sometimes operate as maybe what we would define by their duties as a chiropractic assistant, but sometimes they don't do that at all. So there's maybe whole periods or days or where maybe they're rooming patients and cleaning tables and you know, things like that. And you might still call them an assistant because they're helping you, they're assisting you, but not necessarily clinically. So I think, yeah, I think it's good to consider. Um, but I I don't know that we want to have something where somebody you know, is I think it's such a broad, well-established term to call somebody a chiropractic assistant, kind of across the board. So, you know, including clinical and non-clinical duties. So I don't know. I think that would be the uphill road to do something that limits the ability of somebody that they're calling in a chiropractic assistant in their office versus seeing if we can, for for our regulation purposes, anyone doing these duties is, I don't, I don't know. I feel like I'm kind of speaking against myself when I say that, um, does that make sense? Like, I don't know if we want to limit the ability to use that term,
Yeah,
essentially.
I concur. I think we could end up getting a little too granular, and then we're kind of, you know, kind of talking in circles. I just think that because, you know, so many offices are, in many cases, you know, single practitioners, you know, one, sometimes maybe two, maybe one full-time, one part-time, and they're wearing many hats in the office. You know, they're answering phones, they're billing, they're putting patients in rooms, they're cleaning, they're helping out with the exam, or they're, you know, I mean, there's so many things that they do that to, because, you know, we'll have, you know, we have one of our staff that, you know, primarily all they do is billing, but if the phones are getting crazy, then we'll have them come down and help and support. So they would be technically acting as a chiropractic assistant in that capacity, and they've been trained to do it. It's not something they're doing on the regular basis that the other ones are. So I think it would be safe to say that really broadly in most chiropractic offices, anybody that's in the office that's helping in any way the chiropractic, the primary doctor is an assistant and would probably be called a chiropractic assistant on some level.
So, Ms. Walker, is the request for a motion to move forward with pushing this to the board as a whole? Or are we expecting to see a revised version and then make a motion at that point?
If the committee's comfortable with it, staff is seeking a motion to move the proposals to the board with the addition of the discussion here today around clarifying those minimum requirements for the chiropractic assistant. And then what we would do is targeting that February board meeting date, we would finalize text and bring that forth to the board. So kind of trying to help the committee avoid having it have to come back to the committee again, because you've already discussed all the policy points on it. So I guess, yeah, we'd be looking for just a motion from the committee to move the proposal forward to the board for consideration with final text.
Can I add one more suggestion? So if just staring at the agenda item on the screen, if we read it as minimum supervision and training requirements for chiropractic assistants within a chiropractic practice, if we frame it as minimum supervision and training requirements for clinical assistants within a chiropractic practice, does that make it more, just kind of framing it a little bit differently? So it's not so much a chiropractic assistant, like where it sounds like a title, but it's actually the clinical assistance of patient care. That's really what we want to have the supervision and training requirements for. Does that help with staff and the, like, if we have a motion and do, you know, language move forward? Ms. Walker, I'm asking just for staff purposes.
I think we're okay either way. That does help, because then that puts the emphasis on the clinical component. So if we want to call them out instead of a chiropractic assistant, call them a chiropractic clinical assistant, we could do that as well. It's just, it's not, we're not creating a title. It's just, we have to have some way to reference them. So if that's even clearer, like if it's a clinical assistant or a chiropractic clinical assistant, we can definitely incorporate that in the language in lieu of just chiropractic assistant. If that kind of helps with the clarity component of people that aren't involved in direct clinical care that are also in the office or chiropractic, that might actually provide greater clarity to the public as well when they're reading the regulation.
Okay, thank you.
Yeah, I like that. Is anyone comfortable making a motion?
Yeah, I motion that we direct the staff to use the language to further I don't know the exact language here, but you know, usually you have it written out that it's you know, unless there's substantive changes that we move forward with the language and text that we have right now with some of those.
Text.
Right, but it's sometimes it works.
Some of those edits.
So this is Sabina. Can I interrupt real quick?
Sure.
Please.
So we'd be looking for a motion to recommend to the full board the proposed language to amend California Code of Regulations, Title 16, Section 312, chiropractic assistance with the discussed changes and amendments today.
All right. So, Dr. Adams, did you want to adopt that language as the motion?
Yeah, I mean, Sabina always seems to clarify it and bring it together real well. So yeah, as so
I just
stated.
want to make sure, yeah.
Yeah, I think
Get it
the
all
gist
together.
of what I think the gist is is that the language looks good. Let's move forward so that we can bring it to the full board. You know, I mean, I know there may be some non-substantive changes that are going to be utilized, which is the language we've used in the past. But I think that we got 95% of it in place. I'm on the fence about the term chiropractic clinical assistant. I think chiropractic assistant encompasses that, but you know, that's just my 2 cents. I think that gets a little bit, I think it just gets a little bit too where that, I think that could be a little bit more confusing than helps, because I just think that there's so many hats that these assistants in offices wear that if we start, I think, parsing it out, it could end up making it less clear. More questions. But I think the distinction in the language makes it pretty clear that if they are under direct supervision, that's one thing. They're in training in a sense. They're being assisted. They're being watched over, as opposed to that person that could do things in the indirect setting. They need to have more experience. They need to have more, you know, credentialing, if you will, more, I guess more experience is really what it comes down to, which I like that idea of the, you know, in that context that you shared of the 2,000 hours from that standpoint. But I think it's still all encompassing that they are assistants to the chiropractor and to the practice.
Does the motion remain the same?
Yeah.
That's my motion.
It remains the same to the language that Sabina.
Dr. Adams, is that your motion still remains the same as what,
Yeah, yes.
Okay, I'll second that.
The moderator open this up for public comment.
Thank you, Mr. Chair. I have opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and we'll give you a moment. All right, I'm not seeing any requests for public comment. Mr. Chair, I return the floor back to you.
Okay, I think we're ready for a vote then. Dr. Adams, can you take the vote?
Will. Chair Sweet,
Yes.
Lawrence Adams, yes. Dr. Paris,
Yes.
motion carries 3-0.
All right. Now we'll move on to agenda item 6. Ms. Pitto, can you discuss item 6 for us, please?
Yes, thank you. So this one is basically the same as the previous agenda item. We're going to ask you to discuss the changes to the conceptual language and provide staff with recommended changes and whatnot to move forward with the language. So basically, the committee has been actively developing this language to amend CCR Title 16, Section 318 over the past few years and voted to move the regulatory proposal to the board for consideration last year. During the January 12, 2024 board meeting, the board reviewed and discussed the conceptual draft of the regulatory text, and the board noted concerns with the requirement to document the patient's gender, height, and weight during the initial visit, and also suggested specifying orthopedic and neurological testing as part of the initial examination to further clarify the expected standard for licensees. So the requirement for the patient's gender, height, and weight was in the prior text. However, the language states estimated height and weight is acceptable where the physical condition of the patient prevents actual measurement. So there was some concerns around what that meant, and there was also an issue around gender. So we looked at other programs and they didn't have any gender requirements. So we struck the gender and then we replaced estimated with approximate height and weight because that will allow the provider discretion on how to attain that information. And then also based on the board's suggestion, the examination portion was updated to include orthopedic and neurological testing. And there was also discussion surrounding having pertinent patient history, so that information was also updated. Additionally, stakeholders provided feedback regarding procedure codes not being in the patient file, but in the billing records, so we removed that. And then we also added any treatments or services provided and the patient's response for consistency, and the x-rays or evidence of the transfer of those x-rays based on the fact that it was in the prior text and there was no reason to drop it out. Lastly, we added required to maintain billing records for services performed and ensure accurate billing to provide clarity. So all of these suggested changes are highlighted in your attachments, and we're asking you to review and discuss the conceptual draft of the regulatory language and provide policy direction to staff. Specifically, we really want more direction regarding gender, height, and weight, and also any other suggested improvements to the language that we provided. So with that, I'll turn it back over to you guys for discussion or questions.
Sure. Any comments or questions from the committee?
You know, one of the things that I've been thinking as I've contemplated this a lot, you know, and when I'm teaching my continuing education, I get a lot of response from the practitioners about the fact that the requirement for the detail of follow-up, the initial examination all the licensees that I've spoken with all agree that there needs to be a distinction from an initial exam, obviously to a follow-up or, ongoing type treatment. But one of the things that comes up a lot is this idea of the fact that a lot of practitioners are, wellness practitioners, and people are coming in with not always having a chief complaint, that they become wellness patients that they're kind of following up. And so their notes, because of the compensation level that is attached to a chiropractic visit versus often what's attached to a medical office visit in a medical office, that, a lot of medical doctors are getting compensated as part of the time that they spend with a patient, that kind of justifies the time that they spend on the documentation side of things. So, my answer to them always was that, you still need to, regardless of the situation, you can create a SOAP note, albeit that SOAP note might be, much less detailed than the initial exam. But they bring up a good point about, how much time you spend on those records for that follow-up visit versus the initial visit, and the compensation for that. And that sometimes those notes don't have to be as detailed, obviously, but there should be. So I've been kind of mulling that over, how we do that, how a person can get good notes that are legible and complete, and yet not be spending, say, 10 to 15 minutes on every SOAP note. When you think of some of these busy practices that people have. So I don't know, I thought I'd put that out there. I'd love to get some feedback, from you, Dr. Paris, on some of your thoughts. I know you practice in a little bit different environment sometimes than what, the everyday chiropractor is. So it might be a little different for you, but it's just something I've thought about as I've gotten feedback from licensees and other people commenting on the initial visit versus subsequent visits versus the complexity of the reeval. How detailed does that reeval have to be? When a person may be coming in for wellness, isn't necessarily coming in for a chief complaint every time.
Yeah, thank you for that. Well, I think I'm hearing two different situations. I'm hearing one would be asymptomatic patient in a chiropractic office, and being assessed and the documentation requirements there. And then the second thing that I was hearing was the detail of follow-up visits, I guess, in the SOAP note, like during, a care plan or a trial of care. As I'm hearing those as two separate situations. So let me start with the second one first, just my thoughts. I think everything that's in under 4 and including F, and that would be the subsequent patient visits. I think that's already contained in a very basic SOAP note. Like, I don't think we're adding any burden to what would be like kind of the minimal expectation. And the SOAP just, subjective, objective, the assessment. And a lot of that is carried over. I think a lot of the more current like note-taking systems, unless you're still doing pen and paper, the assessment may not change visit to visit, and the changes in the history or complaints is that can be, I think, relatively brief. So I don't know that we're talking about, like even beyond a couple minutes, sometimes it's, especially if you're in a trial of care or care plan where you already kind of know what you want to do. You just have defined how many times you want to do it. And so that one, I don't know that necessarily that kind of regulates any extra time, to be honest. I think that just reflects kind of a little more detail on what we expect as far as a traditional SOAP note would go. In regards to the first question, I think I think I understand the asymptomatic presentation and the different kind of rationale for, whether it's a chief complaint and an injury, or it's somebody with I guess, a wellness practice would be kind of an okay definition there. And I still think that we really never adjust patients without being a doctor. And the whole reason that they are present in the office is that we have a DC, we have a doctor of chiropractic license, and we still arise to that level of E&M. And what we didn't include here, maybe we could include language like under 3G, that's, pertinent orthopedic and neurologic testing, or appropriate orthopedic and neurologic testing. Because there are the levels, I think maybe that we, there are levels of, this is essentially evaluation and management, right? So this is defining kind of some E&M aspects of what we want to see out of a E&M. And I think there are, so we could maybe put, pertinent or appropriate, history items. And maybe that brings a little bit of flexibility to this, because I think you are correct when you do a problem focused exam, or if you're doing one on a minimal, or absent a chief complaint. I still think before you provide manipulation to a patient, you have to rule out red flags, and you have to do some of the bare minimum. So, but I see your point and that there are some variations in presentation to the office. So maybe we can, maybe staff, we can look at, if we move language forward or motion here, that it just allows for that flexibility to kind of, reflect the range of E&M that can happen. And that's reflected in the coding and, the E&M requirements per CMS and, et cetera. So that's kind of my thoughts. Did I get that right? Did I understand that question?
Yeah, no, that's exactly right. I mean,
Yeah.
I just think in terms of, you create a care plan and somebody follows up and they come in, they're like, man, I'm doing so much better. I'm improving. And, and then, and your notes would effectively be, patient following through with care, and they're, showing progress, improving, rather than feeling like you have to, write down, oh, their range of motion went from here to here. Those are more for a reevaluation aspect versus your incremental follow-ups. Whereas when you do a reevaluation, you tend to be, properly compensated because you're spending extra time with the patient. Whereas on a regular follow-up visit, unless of course something changes, if somebody comes in and says, since the last time I was here, I was doing great, but then I decided to go out and ride my motorcycle this weekend, and boom, then something happens, and that shifts it away. I get all that. I'm talking more about that wellness person also that comes in, that once you've gotten them through their initial phase of care and they're doing better and they want to follow up and be that wellness patient, that isn't necessarily coming in with a major chief complaint other than, I'm just feeling ready, my body's feeling ready for an adjustment. And so you say, patients, wellness patient follows up, feeling a little stiff and sore, no red flags, boom, that type of thing. And I get that, having, practice as long as I have, when people are, manifestly concerned about, oh my gosh, am I going to have this major, burden of documentation put on me? I want to be able to say to them, listen, we're taking all that into consideration when putting these in place. But I always say, everybody, we have to do better as a profession with our record keeping. That's a fact. So I think that's reflected in this creating a standard, is just that it needs to be more than just, where you adjusted that day on a card that's 3 inches wide and 8 inches long.
So just to understand, are you in approval of, like, under number 4? Is that, and as far as like the re-exam or not re-exam, I think we could, it says periodic reexamination is clinically indicated under 4D. Is that sufficient, do you think, as, you know, as far as identifying like which patients are requiring of a periodic reexamination,
Yeah.
and which ones might just be
I do
follow-up
like-
visit? Yeah.
I do like that language better than it saying that it has to be every 30 to 45 days. I think there's indications where, you know, when a person's in an acute, you know, coming in as an acute situation where they're on a program of care, then I think that, yes, that you have to, it's kind of like, you know how it is in practice, Dr. Paris, you know, you get somebody, you know, after 2 or 3 months, all of a sudden you get them to a point where it's like, you know, they're doing really well. And then you recommend, you know, their exercise and stretches, and then they come in and then they, you know, they see you once a month. Well, that's 30 days. Does that mean you have to do a full reeval, or can you do a cursory, you know, check, you know, how's things going, take a little inventory, you know, and then you can adjust them type thing. And then that documentation doesn't necessarily have to be that full. I mean, I get it with EMR systems, you can do things a lot faster, but not every chiropractor out there is doing EMR. My experience is it's about 40% of our licensees are doing EMR, and the rest are still doing, you know, handwritten, travel card, those types of things, and everything in between.
Yeah. I mean, when I look at just concerning the follow-up visit and the need for a re-exam, I think it covers, you know, what we would want, that they would, you know, be required to note any changes in their history or complaints, and then, you know, thus that may stimulate an assessment of any changes in their condition, and then thirdly, the assessment of that would, you know, be, you know, a re-examination. So is it the periodic word in that phrase, the periodic re-examination, that's, I think, as clinically indicated? I mean, if you don't see somebody for 6 months, you know,
Yeah,
you
you
might,
gotta do something.
you might, yeah. I mean,
I think that's clinically indicated. No, I don't have a problem with that language at all
Okay.
right there. I want,
Okay.
and I was looking for it here. And I think you've brought this up in the past, that I think it would be good for us to have in the language that we say, you know, using SOAP or acceptable, you know, charting or record keeping, like such as PART, you know, because some people are going to use the PART, and that's still an acceptable, you know, form of record keeping or documentation.
some language around like generally accepted, or
Yeah.
you know,
Such as PART, SOAP,
yeah,
that
Yeah.
type of thing.
yeah. And those are the two I mean, those are the two major, you know, and that's what's taught, you know,
Right.
the Medicare version with PART. And then so, yeah, I think that's good direction to.
Does that help, Kristen?
Helpful, and I believe we, yes, that is helpful, and we can incorporate language to that effect in the regulation as well. I believe we saw it when we were looking at some of the other states' record-keeping requirements, or it may have been in the SCLB model language, but we've seen something to that effect, so we can incorporate it.
Great. Yeah, the language looks good. I guess I was more thinking in terms of educating staff as well, you know, what some of our licensees are, you know, are feeling and expressing when I talk to them about, you know, in the last 3 or 4 years that we've been discussing this, I've probably had about 1,200 students. And I bring this up every time about record keeping. And there's always some that have a little bit of anxiety, a little bit of pushback. And I think you were present at the last LegCon when one of the questions came up about records along that line. And so there definitely is some concern for, you know, when somebody's, you know, not necessarily, you know, has the resources or has undertaken to get an EMR system, and they're still doing it by their hand. they're naturally going to be a little anxious about what's the new burden going to be on me in this arena. I think this helps clarify that. For me, it does.
Well, so,
I have nothing further. Thanks.
yeah, thank you, Dr. Adams. Did you have anything further, Dr. Paris?
No, I do not.
I will make a motion. Sabina will probably correct me, but I'll make a motion to push the. Go ahead, Sabina. What's our motion?
I was just saying thanks, like you were.
Thought you were
I'm sorry, I was swallowing.
Correcting my motion, but which would be fine.
I think you can do it. I think you can do it.
You don't know me well, but
So we're looking for a motion to. Oh,
yeah, go ahead, please.
are you sure? You want to try it?
I'm
Okay.
sure.
We're looking for a motion to recommend to the full board proposed language to amend California Code of Regulations, Title 16, Section 318, which addresses chiropractic patient records and accountable billings, with any amended changes today. There you go. I mean, amendments today, amended changes.
Yeah, I'll adopt Sabina's language for a motion. We have a second for that?
I'll second that. That was great.
The moderator open this agenda item up for public comment, please.
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and will give you a moment. All right, I see no request for comment. Mr. Chair, I return the floor back to you.
All right, Dr. Adams, can you call the roll for the vote, please?
Yes. Chair Sweet.
Yes.
Dr. Lawrence Adams, yes. Dr. Paris,
Yes.
motion passes 3-0.
All right, thank you very much. On to agenda item 7, and we are back to Ms. Walker to discuss agenda item 7, please.
Hi, thank you. So this agenda item is going to be rather brief. The reason for bringing it before the committee today is that we have 2 proposals that relate to disciplinary guidelines with slightly differing with timelines. So just to provide a little bit of context, this committee over the past 18 months, 2 years, has been doing a lot of work on reviewing the various aspects of the disciplinary guidelines proposal. The committee's gone through in quite depth policy discussions on the various aspects of those guidelines, beginning with reaffirming the trigger language for the uniform standards, which was set at proving it up at a hearing, which was also what the board had considered back in 2014. The committee basically discussed that point and agreed with the prior recommendation. The committee from there, over the course of several meetings, then considered changes to our terms and conditions of probation, including adding new standard conditions for probation that require that probationers maintain an active and current license, that they reimburse the board for the probation monitoring costs, that they be engaged in practice for a minimum of 24 hours per week while they're on probation, prohibiting them from serving as a continuing education instructor while they're on probation, filing their current contact information and employment status with the board, notifying their patients of their probationary status as required by Business and Professions Code Section 1007, and also mandating that they must take and pass the California Chiropractic Law examination based on the rationale that they've already violated at least one of the provisions of the Act or regulations necessitating that probation order through the board. From there, the committee also reviewed and provided various input on the categorization that we have of the existing violations, and then provided input and feedback to staff on the development of conditions precedent for and some guidance for the board on when granting a petition for reinstatement of either a revoked or surrendered license. So all of that, all those different components are there on the policy side. So it leaves with the disciplinary guidelines. The remaining item is for staff to formally draft text and bring it forward for board approval. But we've got that proposal still at the committee level. And then we have a second proposal that the committee has already made a motion to have presented to the board, and that was around the filing and evaluation process for petitions for reinstatement, reduction of penalty, and early termination of probation. So the committee had kind of concurrently been working on and developing a separate CPEI proposal around the application process for petitions for reinstatement. As we're working on that proposal, we're seeing a lot of areas where it overlaps with our disciplinary guidelines. So we want to take the two proposals and join them together and move them together because there's certain aspects to the application process that need to be spelled out separately in regulation, but then there's guidance behind those processes that fits better within the disciplinary guidelines. So where we're at today is we've basically got two regulation package or regulatory proposals. We haven't approved, the board hasn't approved text yet, so we're just at the proposal stage, but we've got two proposals, slightly different timelines. We're proposing to put them together, and then for purposes of the committee discussion, we need approval one way or another of where we're going to go next with the proposal. So if there's concurrence on putting the proposals together, we are seeking either a motion from the committee to move the disciplinary guidelines and uniform standards text forward to the recommendations around that text forward to the board for approval, or we would be looking for the committee to direct staff to take that filing and evaluation process for the petitions for reinstatement and return that back to the committee. So we need to put them together. So it's either a motion from the board to take the work on the disciplinary guidelines and move it forward, ideally with that other proposal at our February meeting, or decide that instead of taking that petition for reinstatement proposal to the board in February, bring that back with disciplinary guidelines to the committee in the spring. So we just need to make a more of a housekeeping decision, if you will, on today's call, so we know where to direct that proposal.
Well, do you have a suggestion? What you feel would be best?
My recommendation, especially in light of so with the record keeping proposal that we just discussed, we had shared a draft at the board, and then there were some additional policy questions, and it ended up being returned. So for that reason, my recommendation is if we can get a motion to move the committee's recommendations around disciplinary guidelines and uniform standards forward to the board for consideration. We can present that in February, and if there's any additional policy questions or work, we can then bring that back to the committee in spring and bring it back again to the board in April for approval. So it speeds up our timeline a little bit. So that's my recommendation, is to do it that method versus going to a committee, bringing to the board in April, and then if the board has issues with the proposal, not looking at text until July. So my recommendation would be to take the disciplinary guidelines and move it forward, because the committee's already provided staff with ample input on all the various policy aspects within those guidelines.
Then I motion that. Can I just do that, Sabina? Just motion what she said, that what the staff's preference would be. Is that acceptable?
Yes, because she included in the beginning that it would be recommendation to the full board to move this proposal there. Thank you.
Well, that would be my motion,
I'll second.
if that's the most expeditious.
I'll second that.
All right. Moderator, can we open this up for public comment, please?
Thank you, Mr. Chair. I've opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Mr. Chair, I return the floor back to you.
All right. And, Dr. Adams, can you take the vote, please?
Yes. Chair Sweet.
Yes.
Dr. Adams, yes. Dr. Paris,
Yes.
motion carries.
All right, that one was easy. Agenda item number 8. Any future agenda items that the committee would like to present? Nothing from the committee at this point. The
My,
moderator-
my question would just be this, the second half, Kristen, that you had said that you suggested the one section move forward, the other section, should we put that on a future agenda item, the second section that would remain in committee and have that be for further discussion, or was that already tacit?
That second section, the committee's already made a recommendation to move it forward to the full board. So we're combining those two together and presenting both at the board meeting. So not necessary for a future agenda item. We've got the policy discussion there. I would like to note under future agenda items that with the recommendations today, this committee for now has no additional conceptual regulatory proposals in the works. We've polished off all of them. So there's plenty of opportunity there for any future agenda items that the committee might want to discuss because we no longer have pending regulatory proposals that need to be vetted through this committee.
If you're saying we're too efficient, then I concur. Thank you, Ms. Walker. Any other future agenda items from the committee before we move to the public?
Well, I guess if that stands to reason, I would suggest that perhaps staff get together, and I'm not saying to create yourselves work, but I'm saying if there are items that you see that should be, I think that would make sense that if you guys as a staff come together and things that we should be starting to address, I think that would be valuable feedback from the staff.
Sure, thank you. And I would just add on that point, because we had a pretty robust discussion about it at Government and Public Affairs Committee, is that as we're seeing some additional kind of room there at the committee level for some work, we do need to do a little bit more in outreach components. So if we can divvy that up between committees as it relates to enforcement type activities, that's one potential future agenda item is around outreach and getting some assistance from the committee in that area.
All right, very good. The moderator, open this agenda item for public comment, please.
Thank you, Mr. Chair. If any member of the public would like to comment on future agenda items, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and will give you a moment. All right, see no requests for comment. Mr. Chair, I return the floor back to you.
Okay, agenda item 9. I will entertain the motion to adjourn the meeting.
Motion to adjourn.
I'll second that. We'll forego the vote for now, but I think we're all set unless there's anything else, Ms. Walker or anybody on the committee. All right.
Did we want to set a time or doodle pool for the next meeting time since we don't have anything pressing? Did we want to set in the next meeting time?
It's easier for me if we do poll it. It gives me a chance to pull up calendars.
You would almost beat me in the door.
Yeah, agreed. And then that'll also give the staff time to figure out if there are other items that need to be placed on the agenda. Okay, then if there's nothing else, I will adjourn the meeting, and the time is 1:59. Thank you, everyone.
Thanks, everyone. See. Happy holidays, everyone.
Mhm.
Happy holidays, everyone.
What are your thumbs? Yeah.
Be safe.
Always like.